Hello everybody, my name is Brian Latanville with Healthy Home Makeovers.
I'm Chris Potts with Norseman Construction, and with us today is Chad Kopach from Blaney McMurtry. Chad is a litigator, head of the construction department with Blaney McMurtry. That is a firm that's been around for a long time. If you don't know the name McMurtry, I'm sure that Canadian history will be able to teach you something about that when you Google it. Anyway, Chad's here today. He's going to be speaking to us about many various aspects of construction law, specifically to do with your house. Residential construction, residential design. That's what we're specializing in on this particular podcast today, and we hope that you enjoy our show, especially with Chad. Thanks very much, Chad. Why don't you tell us a little bit about yourself?
Well, thanks for inviting me on. I really appreciate the chance to come on. I am a litigator at Blaney McMurtry. Blaney's is call it a mid-sized firm for Toronto. We're about 130 some lawyers. We practice a full-service firm, so everything from soup to nuts on enforcing contracts, drafting contracts.
Soup to nuts is a legal term.
It is definitely a legal term. You can look that up. Yeah, that's right. Personally, I've been at the firm since 2002. Articled there and started practicing right away in commercial litigation with a focus on construction law. And about 3 or 4 years ago, maybe 5 years ago now, time tends to slip away, I got my certified specialist designation from the Law Society in construction law. So most of my practice is in the area of construction law.
So just so everybody knows, a litigator is a modern version of a Roman gladiator, my dad likes to put it. So what that means is, this is the man who will fight the fight in the front line. So, and that's what a litigator actually means. And when it comes to construction law, that's very important because he's the specific lawyer that you're going to talk to when it comes to a dispute with either your contractor or your contractor having a dispute with you, which is very, very important to understand that.
And one thing that starting off in a dispute resolution and litigation has taught me is the best way to avoid a dispute or litigation is to make sure that you have a solid foundation in your contract at the front end. So after spending years of fighting over what a term in a contract means, maybe I'm a little slow on this, but I learned, well, maybe let's go at the beginning and try to sort it out and get some clarity on language so that we don't have those fights at the back end. So that's if I was doing 95% litigation, construction litigation 10 years ago, 15 years ago, now I'm doing a little bit more preventative measures by doing the contract negotiations, making sure that the contract says what everyone wants it to say, not what they end up just hoping it says what they want it to say. Right?
Basically answering our first question, what should a well-written contract contain, right? So the language should be right, like you're saying?
Right, it should be, it should be simple language, first of all. There's, in the last sort of 10, 15 years, there's been a trend towards using everyman language instead of legalese. Lawyers are very good at creating their own language where words tend to maybe have multiple meanings or mean something totally different than what you thought they meant. So it's drafting contracts that are easy to understand in layman's terms.
However, what we also have to understand too is there's also variants of contracts that are out there that are standardized. Can you explain sort of what that means, standardized, like a CCDC? We've heard that quite a bit in the contracting world, and it's a type of contract which is available to homeowners that is a specifically written contract that stands for,
it's the Canadian Construction Documents Committee. So it's a group of individuals from industry-wide representing owners, subs, general contractors, lawyers always get to stick their nose in there to make sure that they get their say. But it's a standard form contract, so there are different types of contract depending on the payment mechanism, depending on the role of the contractor on a project. And it's a bit of an interesting way of negotiating them and changing the terms, because like any contract, it's going to be a one-size-fits-all, but maybe one size doesn't fit all for every project.
I've noticed this. So in our company, at Norseman, I run into this quite a bit, and it's various clients. They would have version of the CCD contract that a lawyer had taken. They've cut out pieces of it. They've put other pieces of the contract together, and you end up with this quasi Frankenstein kind of contract that's been put together. Sometimes the homeowner puts it together using pieces of CCD contracts.
Yeah, and so I guess as an initial point, that's the wrong way to do it.
That's what I was trying to get out of you. Is that a good thing to do for our clients?
100% not.
No.
Right? So the way to do it is the CCDC stands on its own, and there are no changes to the face of it, with the exception of there's sometimes little form areas to fill in, price, for example. It's one of the key ones. But changing the actual terms of the contract is not supposed to be done on the face of that document. It's done using something called the supplementary conditions. So it's really it can be a little bit complicated in that you have to read the CCDC document side by side with the supplementary conditions. Now, ideally, the supplementary conditions wouldn't be more than a page or two, but they will say things like, in section 7, instead of you having the word "and," we'll take that out and put the word "not." So just so that you can change the meaning of the standard form document using these supplementary conditions.
But should a homeowner be doing this themselves?
Probably not. Like, most homeowners would probably not have the acumen to be able to create that. Now, that said, it should be able to be read together so that if you have that document presented to you by a contractor, you should be able to read it and it should make sense. Now, just as a lawyer, I've got to put this plug out there. You do want to have these things reviewed by counsel. I know that it's usually more the exception than the rule, but to make sure that nothing's getting snuck in there that you aren't expecting, or you think that the contractor is going to say one thing, but it actually says something else. You want someone to help you out on that, to point that out.
So should a construction lawyer look over all renovation contracts, or is there like a size and a
best case scenario that would be what I would like to see.
Yes.
But of course, it's going to cost, right? So if you're
now, is this expensive?
Expensive is relative, right?
Well, I'm just asking because this is a very important question. I mean, you got to remember now, in our past shows, we went over a few things. So the clients now paid out money for an architect or an architect technologist. They've put out money potentially for HVAC permits. They've got city fees that are going to have to be paid. They've got a wealth of money that's just been put out to try and get a $50,000 renovation done. Now they've got, they're going to have a contract put in front of them by their contractor or by the construction company or whichever firm or whichever facet of construction method that they've chosen to go down. And that contract is going to be put in front of them. And most people, they're very, very easy to sign. We sign our house, as I mentioned earlier this afternoon, with an agent, and it's usually one signature, and we've bought now a $1 million mortgage, especially in Toronto. And you buy a car, there's 15 to 20 pages, and you're signing and autographing each one of them. I bet you 90% of people don't read any of that stuff.
Sure.
So now a contractor comes to you with a legal document that is most likely prepared by himself or been modeled after his own needs, and most people are going to sign this. Now, from your experience, obviously, now we're going to lead into a lot more things with this.
Sure.
But in your experience now, if that cost is an additional amount of money, they're already looking at their wallet going, oh my God, this is going to cost me a fortune. I don't want to do this. How much was this? What are we looking at here? $500, $200, $1,000?
Yeah, I mean, I think $1,000 is reasonable. It's going to obviously depend on the length of the contract and the supplementary conditions, and as well, it doesn't help for a lawyer to just look at this thing in a vacuum. Right? The lawyer's got to meet with you and figure out, like, what are you trying to do with this contract? What do you want this contract to do with your relationship with the contractor? And does it do that? So, yeah, I mean, $1,000. Now, most lawyers charge by the hour historically. So, you'll get someone saying my hourly rate is $4.50 an hour. But on a project like this or a job like this, a lawyer should be looking at that and say, okay, look, it's going to take me this much time. I will do this for $1,000 or like $1,250 or something like that. A flat fee, right? It's about it's about managing expectations on the fee front. Now, that said, the value of getting a $1,200 review of the contract can just be
See that,
head of
guys?
the
It
park.
just went up to $1,200. Just so
gotta
we're
add-
watching here.
We got to add HS.
There's an extra 5 minutes in there, right?
Government's got to get their piece. Well, no, but the issue is $1,200 spent today could save you $12,000
Yes.
at the back of the project, right?
I
Just to make
totally
sure that
agree
you've
with
got that.
So like a
safety.
renovation for say $50,000 versus a custom home build, like is that going to be a slightly different contract? Is there's going to be more things to look over, so that might take more time, right?
Yeah, it definitely could be, and there could be more responsibility that the contractor is taking on as the sort of owner's rep on dealing with the city and dealing.
Yeah. Because
with
you might have
various
other,
levels.
maybe just not one construction company, but other trades people that you're separately working with, right? 'Cause
Right.
those could be all different contracts.
Sure, definitely. Yeah, and it's also going to depend on the. We'll get a little bit deep into this now, but on the project delivery model. So, is it a general contractor model where you hire the contractor and the contractor hires all the trades themselves, or is it more of a project management model where the contractor is sort of off to the side doing the coordination, but all the contracts of the trades are with the owner directly? Like
We
there's-
went
they're
through
responsible
that
for,
actually on
yeah.
our last show.
yeah, there's
Yeah.
all sorts of ways to
So obviously there would be more contracts for you to have to look over
Sure.
in that case, right?
And now with the CCDC, though, does have a standard set of documents
Okay.
that sort of ties all of those in as well. So I just can't say enough about the CCDC form in general. It does need a little bit of tweaking to make sure that it
Yeah.
fills in some of the gaps that are there, and project-specific issues as well.
So now I know in our firm, we don't use the CCD contract, but we'll use it if a client would like to use that. We use our form because we find it easier to work with, and it's less of an explanation method when we sit down with a client. Our contract is large, however, the CCD contract is vast, and there's a lot of complexities to it. So, with us, we find that we will definitely use that contract, but we'd like to use ours. Is there a difference, do you think, between the two, a generic contract and a CCD contract?
I mean, odds are that your contract probably has a lot of the same things in it, just said differently. And when it comes to someone in your position, it's actually about the efficiency of using a standard form. So even though yours is a bespoke contract, it is unique to you, and you use it in all of your projects. So you're able to sit down with the client and say, now here's our contract. Here's what we're doing with this term and this term and this term. Here's what we're responsible for. Here's what we're not responsible for. And that's one of the key things about drafting the
scope.
contract, is making sure that people know exactly what they are responsible for and what's going to be left to be dealt with by someone else.
And that's something we went into depth before, as well as controlling your job scope. It was actually our first show. We went into understanding how a homeowner should actually control that job scope so that they can get an apples to apples quote. I mean, one of the hardest things though is actually taking that and getting that job scope. And in our second show, I believe we talked about the different facets of people you can work with to gather the information to compile that job scope within that would then go into the contract.
Right, and that's a very key point as well, and something the CCDC does very well is it has a section to make sure that all the documents that were created, went back and forth before the contract is signed, like job scope, get listed in there as contract documents to make sure that you're carrying forward everything, so that everyone knows that when we're going to come time to implement this contract, that the scope, for example, makes its way into the contract.
Yeah, no, fantastic. And I'm not in the construction industry per se, like Chris is, but some of the things that I hear from different people, and a lot of the complaints are that the contractor didn't do the work, didn't finish. So what happens if the customer decides not to pay the contractor? This is fun, right? This is the fun one, right?
Well, that's when somebody's going to call someone.
Call
like
you.
Right? Yeah. And say, look, we've got this issue.
Yeah.
I didn't get paid. So
the contractors call you too, as well as
sure they do. And that's the thing at our firm. We do work for everyone up the construction pyramid. So everyone from suppliers, trades, contractors. We work for owners. We work for lenders as well, because sometimes they get caught in the middle of these disputes.
Yeah, for
too.
sure.
So so what happens when you don't pay? Well, the first thing is usually a very strongly worded demand letter saying you better pay. Now that said, the CCDC document as well, and some people's changes to it do have a mandatory mediation or negotiated resolution mechanism. So ideally you start there, right? If there's an issue that comes up on the project, there's a way of dealing with it. You go
However,
to the
now
owner's rep.
that actually breaches into quite a bit of understanding for some of our clients who are not in the legal realm and don't understand. You just mentioned two pretty big resolution items, and one of them being what's it called? Not negotiation, but
Like a mediation?
A mediation.
Yes.
Now, mediation is a big term, guys. It's something that it's not about just sitting down at a table and yelling at each other. It's actually renting a specific location where it's neutral between both parties. It becomes very costly. So when you see that word negotiation or mediation in your contract, make sure you understand what that actually means, because it's quite a very difficult procedure to get through. You want to break into a little bit about that, like how that works?
I mean, in Toronto especially, we have a mandatory mediation in the context of litigation. So I'll talk about what it means there.
Correct.
It's, when we see it in that situation, the action has already been, someone's been sued already, someone's put a defense in, and usually documents have been exchanged. This is why, here's the documents that say that I'm right, here's the documents that say I'm right. So then you, with your lawyer, each side with their lawyer, would go in front of a neutral third party, a mediator, and present their case about why they think they're right and why the other side's wrong, and the other side gets a chance to do the same. And then the mediator spends usually a day. I have to say, on these home reno cases, sometimes well into the evening, so you have to make sure you've got your childcare all sorted out, because these things, like the idea is the mediator is going to get this thing sorted, going to get everyone
goal, right?
to sign off and enter into something called minutes of settlement to settle a dispute. So that's what it looks like in litigation.
Who pays for that?
The parties pay for it themselves, right?
So each party pays
for
their own
that.
money for the mediation.
That's right, and pays half the mediator's fee, typically.
And what typically are we looking at with something like that?
Yeah, it's a few $1,000s easily.
Five,
yeah.
So $5,000.
Sure.
Okay.
Easily.
Right.
Yeah.
And you got to pay for your lawyers, obviously, time.
Yes.
And at this point, let's backtrack a few seconds. So you've got into a specific debate at the end of your project. And we'll take it from our homeowner's perspective. Mm-hmm. We all know, and I know as well, being an owner of a construction company, that you get into a point in the job where you're almost finished. You're at 97% completion. Mm-hmm. 97% completion. We're going to get into what that term means, as well as substantial performance, which I'd like our audience to understand what that means as well.
Sure.
But we're at the end of the job, and you're unhappy with the work that's, as Brian said, that's happening, mm-hmm. and you don't feel like the contractor should get paid his money because you want to hold that money. Now, the contract states that once you've hit a certain stage, that money needs to be released.
Sure.
And there's then a certain amount of time, and this is we're going to get into what a lien is, mm-hmm. correct? So that time and that information that's in your contract that gives you that time where that amount has to be paid, then if they don't pay, then are they in breach of contract at that point?
It's going to depend on the terms of the contract. So oftentimes the contracts will say, will provide for a holdback to the extent that there are deficiencies or that there is incomplete work, and that sort of a justifiable reason to hold back.
I just have a question here, just talk about this. So, sure. What is the standard payment formats? Like, is it like 40, 40, 20%, like 40 up front, 40 halfway, or is there just, it's all in the contract?
It all depends on how the company's broken it down. I mean,
okay.
And what I found, Brian, is like, in our firm, we do as many payment markers as we can so that the client feels that they're being paid for the work that's in place, rather than taking a huge amount of money up front, which can be dangerous. I mean, that leads you into major problems with a potentially contractor just leaving with your money.
Well, I've heard that, right? The guy, I need the material, I need materials, mm-hmm. and then I need X amount of dollars for materials ahead, which is a large chunk, 40, 50% of the contract, and then you don't see them.
Yeah, right? Rather getting into like that kind of broad idea, let's try and keep it onto more the specific of where we were going with regards to ending up in a lien situation.
Sure.
Because though you're right, that ends up in a problem, but right now we're talking about if a client is not comfortable with paying the final amount of money to their contractor, there's issues that are left that they're not going to budge. They want this guy to come back. They want this guy to finish the work, but they're not happy even with the work that's being done, and they're not going to pay. So they decided, we're not paying you, and we feel that you've been paid enough.
Sure.
And what happens at that point?
Typically, if I am acting for a contractor comes to me with that situation, then what we'll do is we'll put a lien on. So
what's a lien?
A lien is a document that you register against title to the property, and it is a charge on the property. And
a charge means it's a mortgage,
it's like a mortgage, yeah.
So a mortgage goes on the back of your property.
Right.
And you can't get it off.
You can get it off by paying money into court equal to the amount of the lien plus some amount for security for costs.
So you have to pay that money into, now you have to pay the court. Now you're going to have a lawyer and you're going to pay into court.
Yep.
So either way, the money's going to get paid in.
And I should say that's not something you can just do by yourself. You can't just go to the court by yourself and with a check.
Yeah,
You're going to have to hire a lawyer to pay that money into court and get the accountant's receipt, and then get an order that says that lien comes off title because the money's now in court, and then you register that order on title, and then the lien comes off. And then at that point, the lien is on the money that's in court.
Got it.
That's how the act is.
So they use they use your property as an asset to guarantee that you put the funds that you've now decided not to pay into court.
And just as we'll go back 150 years or so. So the reason that this stuff came about is because, actually we'll scratch that.
No, go into detail. That sounds actually really interesting.
So
why did that happen?
What we should do is first contrast it with non-construction disputes.
Sure.
So if you're just owed money from someone and you go to sue them, you sue them on day one, and then day 700 or so, you'll get in front of a judge, and a judge will say, yeah, you're right, you have to pay them the money. Well, in that period of time, perhaps they've gotten rid of their house, they've gotten rid of all their assets, everything's gone. So now you have a judgment, but you have no way of executing against that judgment.
Yes.
But with a lien,
so that means you can't collect.
you can't collect. You've got a paper judgment.
You're talking very lawyer-easy.
That's what I'm doing. I'll try to bring it back a little bit.
That's what he's here for.
But with the lien, it's called execution before judgment. So you get to cloud title to the property, or you get to have the money bound up in court, so that when you win your case, the money is there or the property is there. And so if the lien hasn't been, we call it bonded off, or their security hasn't gone into court for the lien, theoretically, after trial, and the trial judgment does not get paid, then you can sell that property, and in certain circumstances, you can sell that property and get paid.
So you can force the sale of a house. So
now I should say it's very rare that actually happens, but that is.
So I want to go in a little bit. What's the 150 years ago part where this came out?
Well,
I want to know what that means.
It's just the and it's probably less than 150 years, but it's the reason for these mechanics liens or builders liens as they used to be called. It's to make sure that people in the shoes of a contractor or trades are going to get paid, because too often you would have seen situations where owners would have just gotten rid of their assets,
sold everything and took off.
Yeah, and pocketed the money and
go out west and dig for gold.
Right. And so this is a way of making sure that security stays where it's supposed to be until the whole mess gets settled.
All right, fair enough. Okay, so now we've got the contractor's side of things, and the homeowner now is he or she has decided not to pay. The lien's gone on. Now let's flip that around. What happens if the work's been done, our client, our audience has paid our contractor in full, and the work just is not done right. And now we're not going to get into Tarion because we haven't touched that topic yet.
Okay.
We're gonna stay out of Tarion. This is not a new build. This is now we're into renovation. Sure. What's their recourse? How does a homeowner now deal with the fact that they just had a renovation done? They've spent over $200,000, maybe more, and the work is not done the way that they want it to be done, and they've paid everything at this point. So what's their recourse?
Well, I guess from an initial point, they shouldn't have paid everything, because the Construction Act does require a 10% holdback until the project.
How long is that? Now let's touch this now, because we're into this. So there's, on most contracts, and you're going to see this because we're going to touch the Lien Act shortly, but there is this, what's called a substantial performance and a substantial completion. And these are at the end of the contract. And usually this defines a certain set of terms. And there's actually a clear way of finishing out a project, and it's step by step. And it includes publication in a paper. It includes...
it can, yep.
It can, okay. And it also can include, that way, validation to trades that everybody's been paid. Go into a little bit more detail what those two words mean, so that our clients can sort of understand what that actually means.
Sure, and I guess
audience, not clients, guys.
Substantial completion or completion is more of a building code term when that is closed out. But substantial performance is a very important concept in the Construction Act. So the 10% holdback is maintained up until the end of the called the end of the project, and that happens when the project there are percentage milestones, and this would help to have the actual act in front of you to show exactly what those percentages are based on the value of the contract. But once that milestone is hit, 45 days after that contract has been substantially performed, then that 10% holdback
marker kicks in.
Can be released. Yeah, no problem. It can be released. So actually, there have been some changes to the Construction Lien Act, now called the Construction Act, as of last 2 Julys ago. Now it's the holdback shall be released. So it now has to be released unless there is a set-off right that the owner is advancing against those funds. So what happens practically?
So go this a little slower, because it kind of just. So we've got a contract. It's $100,000.
Yep.
We've reached 97% of that job performance being completed. And is that point now we're called substantial performance?
Yeah. Again, pull the act up to get the exact definition, but let's call it that. So let's say that that is the job is now substantially performed. Then 45 days after that, the 10% holdback has to be released.
Is it 45 days or is it 90 days?
Okay, so that's the issue. If it's a contract that was entered into prior to July of 2018, July 1, 2018, it's 45 days. If it's after, it's 60 days.
Okay, so that we're touching a lot of complexities here, and I just want everybody to understand this. Brian's looking at me going, what the hell are we talking about? But I want to make sure
I'm getting it. I'm learning.
This is
I love these
complicated
shows.
stuff, but it's very serious that everybody understands this, because contracts and these particulars are specific for homeowners, especially when they're dealing with contractors at the end of the job, because this is the serious part of this, where it really, 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 really is the most important. I can't even preface it this. I'm going to say really, really again. But at this point, you are in a position to make the decisions on where your project's going to go. Are you happy with this project at this 97%? Is this something that you feel is the time now that you're happy with the job and you're moving forward? You've listed your deficiencies at this point, correct? And those deficiencies are noted down. And in that period of time, the contractor and you hopefully are able to complete the items within the contract. And you have, as of July of 2018, if you're prior to that, you have 45 days to release the funds. If after July of 2018, you now have 60 days to release those funds. Now, is this a negotiable release of 60 days, or is this you have to, or then you're in breach of contract?
Yes, so it does say shall, unless you've got a reason to. And actually, before we do get into that, I want to talk a little bit about the reason for these funds being held back. The idea is that these holdback funds are really for the benefit of the subtrades, the subcontractors to the contractor. So if they're not paid, that's the window where they can come out and say, I've got a lien because the contractor hasn't been paying me, so those funds are available for that group below the contractor. So, assuming that there has been no claim, then yes, then and it historically has been a bit of a negotiation to say, look, okay, I've got $10,000 in our example. I've got $10,000. The period of time has now expired. This is money that would go to you, contractor, but let's talk about these deficiencies.
Okay.
Or let's talk about the fact that I was supposed to get into my house August 1st, but I wasn't into my house until September 5th. Like what are you going to give me for that? So that has been historically how we've seen homeowners try to, or not homeowners necessarily, only homeowners, but owners try to use the provisions of the holdback provisions of the Act to say, okay, now it's time to negotiate how much of this you're actually going to get.
Is that typical?
It doesn't, I wouldn't say it's typical, but it happens enough that there's now, as of October 1, 2019,
oh man, here we go.
going to be a new dispute resolution mechanism, a new quick and dirty way of getting your money if you are owed funds that aren't getting paid down.
So what does that mean then for homeowners who quite rightly have not had a good job, and now they're in a position where this job is, they've held their money back for good reason, and they don't want to release it because the job's done very poorly. How does our audience now deal with, let's say, a bad contractor who's going to use this potential new way of dealing things to his benefit, and maybe go into a little bit more detail of what that is?
I guess before we get into, and we'll just put it as a placeholder here, it's called adjudication. So we'll just mark that down, we'll talk about it a little bit more. But the bad project can't just be I feel bad, I wasn't terribly happy with how I was treated on the project, you didn't communicate with me properly. It has to be a real problem, a real actual cost in order to advance it. So you're going to be going back to the contract and you're going to look at it and see, okay, is there so for example, my lateness issue, is there a liquidated damages claim for every day that you're past the
and that would be in the contract.
That should be, it has to be in the contract if you're going to be asserting it, or otherwise agreed after the fact. So that's what those funds can be used for. You can set off against those funds once they are no longer holdback funds, once that period of time has expired, out of the 45 or the 60 days has expired, and they would otherwise get paid down. Then you can look at your contract and say, okay, what are the deficiencies? What am I entitled to set off against? And then what gets paid down? Now,
you mentioned something earlier about adjudication.
Yeah.
So do you want to go a little bit of detail on what that means? I know that's a big word.
How much time
I know. Well, can we have the Coles Notes version of what that means?
So I guess you could have the Coles Notes version. You're not going to get the Coles Notes version. We're going to go a little bit in depth here. So about 4 years ago, the government of Ontario decided this Construction Lien Act, it's not really working for us, so we've got to revamp it. Other jurisdictions are doing different things. So first of all, we don't have prompt payment legislation. So we leave it to the parties to say, I put an invoice in and you should pay me 30 days later. Okay, that happens. But then that was 45 days, and then it actually creeped up to about 57 days payment terms, right? That's what it was being extended to. So the government had said, okay, we need to legislate this, and we're going to put 28-day payments in. So from the day of a proper invoice that goes in, 28 days, and then the money has to flow down. But like anything, having a right or having a legal requirement doesn't really mean much unless there's actually an enforcement mechanism, right? So to enforce it, they're bringing in at the same time the concept of adjudication. So an adjudication it's not a court process, and it's not an arbitration process, it's not a mediation. I called it quick and dirty. It's probably unfair, and I don't want to tarnish the thing before it actually comes in. But someone who's owed money, a complainant or a claimant, will put in a notice of a dispute, and the party who is said to owe the money puts in a response, and an adjudicator will look at the request and look at the response and make a determination. And so that will happen, and this is legislated, it has to happen within 45 days, where you'll get a written reasons for decision. Either yes, you use the very basic one, yes, you're owed the money on that change order that wasn't approved, or no, you're not owed it. And for determinations that money is owing, that money has to be paid, I believe it's 10 days. And if it's not paid in 10 days, then that decision can be enforced like a judgment. Okay?
Interesting.
So in that respect, it's very quick. just because it is so quick, as a litigator who's used to measuring these disputes in, well, not months, in years, fulsome time allows the facts to come out, and that's the system that we've been dealing with. There are going to be mistakes made, right? There's going to be, not all the facts will come out, or the adjudicator will get.
But maybe, sorry to cut you off, but maybe, there is the difference in time may appeal for more smaller cases. I mean, the cases that you're speaking of are large cases that have many aspects of things and complexities to them, and we're talking potentially of millions and millions of dollars. But a smaller case with $150,000 where the lien is maybe only $10,000, that's going to speed the process up. It's going to allow for an expedited ending to something that, for instance, could last years, over $25,000, $30,000, where legal costs on both sides mount over to $100,000 just based on dispute resolution. And you're not going to get that money back, just so everybody understands.
Well, and on one thing you did mention there, though, is ending, right? So the ending.
Yeah.
The problem, benefit, whatever, is that you get a decision, you get paid, but that doesn't necessarily end it, because through the legislation, the adjudication decision is not necessarily final.
So they can appeal that.
It's not an appeal. You can sue. You can. It's a. You go to a new process, and it's heard afresh. So it's not an appeal, in that sense, which maybe we're splitting legal hairs now, but you can still sue someone. Or if you're a contractor who didn't get paid, you can still put a lien on and go through the lien procedure as well.
Oh, wow. So this has just opened a whole world of complexities to this now.
Yeah, or hopefully,
guys,
hopefully
I did try for a Coles Note version of this. However, I don't think we're going to get a full Coles Notes like Chaz mentioned here. But
this might be a whole other show.
We might have to. Yeah. But I mean, if I was to sort of give you a synopsis of that so that everybody can understand it, I think a little bit clearly, if I can put it into perspective, we're still going to be maintained. There's still going to be a lien being maintained. There's still substantial completion. There's still substantial performance at the end of your contract. There's going to be a time in which for the contractor to complete those deficiencies and repair them. There's going to be an amount of money that needs to be paid at the end, whether you choose to pay it or not, depending on where you stand as far as your happiness with the completion. Then if you choose not to, there is the option for a contractor to put a lien on, which would then protect his trades that are owed money. And at that point, you would have to pay the money into court. Am I going right with this?
Unless you're okay having the lien sit on your house. But yes, typically people want to pay it into court.
Yeah. So the money, if you are okay with having a charge or a mortgage on the back end of your house, I don't know how that's going to happen. If you're going to refinancing after your construction's complete, that might be a problem. But the money then goes into court. At that point, there is...
So this is, you're hitting on actually one of the problems that some owners or some people who are representing owners have hit on is, okay, so you've got a lien on because you've got a dispute, right? There's a dispute and you're not going to pay it in the face of this dispute. So the contractor puts a lien on, so you've got to deal with that lien. So you put the money in because your mortgage company has said, what is this thing doing on there? Get rid of it. So you put the money into court, that gets rid of the lien. At the same time, the contractor starts an adjudication, okay? And within 45 days, possibly, there's an order that the owner has to pay that money. In that circumstance, the owner has to pay, in essence, pay twice. So they've got to pay that money.
Take it out from the lien.
You can't just scoop it from there and go there. Now, I think probably what's going to happen is there's going to be some sort of resolution because the contractor's going to say, well, I already got paid, so if you're willing to sign this release saying that you're not going to come after me to scoop that money back, I will allow you to get your money back out of court.
Oh, wow.
So that's how probably it's going to happen. Now, look, this adjudication thing, we're not even early days yet. And it's only going to impact and reference timing on a podcast like this is always difficult because you don't know when people are going to be watching this, but it doesn't come into effect until October 1, 2019, and then it's only for contracts that are entered into after October 1, 2019. So, we're not there yet. It's literally around the corner.
Definitely something to think about if you're going to do a renovation.
Definitely something to think about, yeah.
And we're going to see this appearing in all contracts going forward?
So we've borrowed this concept. It's something that's happened in the UK for ages, 20 years at least. They've had it in the UK, and when they introduced it, they only introduced it for certain contracts. But we've decided that we're not going to have that sort of phased-in approach. It's going to be everything from the $5,000 reno to the $5 million new build. Like this applies to everything.
In our company, with regards to the different aspects of conflict, our company's been in conflict, and we've also been on the other side of each aspect of the conflict.
No way.
Yeah.
No way.
Yeah. So, I'm not saying we're perfect. Construction, as we've talked about, is chaos, and it's stressful for everybody because there's a lot of complexities that go into it. We're dealing with lots of different people, and as we mentioned, lots of different trades that can potentially cause problems.
And you're dealing with someone's home, right?
Right.
And you can't discount the emotional factor of when there's even a perceived issue with someone's home. Like they're going to treat that.
Well, it's the single biggest investment of your life.
Yeah, one thing we always talk about, it's one of the most stressful times too, doing a renovation or something like that, right? So of course there's a lot of high emotions that run.
How much, and this is what I want to get into, is how much is this going to cost? If we've gotten to a disagreement now where we can't resolve, and each party is going to start to actually start this conflict, and adjudication steps in, and now they've deemed that the contractor gets his money, and you've now paid this guy his money, and now your money is still sitting in there, and where does this go?
Sure. So before we get to the sticker shock of how much this is actually going to cost, I do have to say, and we're hopeful that we have a similar experience here in Ontario, but the UK experience was about 90% of disputes actually stop after the adjudication process. So, you might not get the exactly right answer.
Well, they can't afford to go any further, right?
Well, that could be it. But to Chris's point, like you've paid this money and this is my home and now it's a matter of principle. Damn the torpedoes, I'm going after that money. I'm going to get it back. Yeah. So what does it cost? Like, again, it depends on the contract, it depends on the dispute, depends on the defenses that get put in. But
we need a number though.
Oh, you're going to get one. Like it's
we're going to get one, guys.
It's easily
happen.
It's easily $50,000-$60,000 of legal fees when you look at exchanging pleadings, exchanging documents, doing examinations for discovery, which is where each party's representative gets to sit the other side down, ask questions under oath about documents, about allegations made in the claim and in the defense. Then you have a mandatory mediation, a pre-trial, and then a couple of days of trial, 3 days of trial, 4 days, 5 days of trial, and each day of trial, generally you budget about $5,000. So,
how long does that take, like timeline-wise?
Like, I'd like to say we could measure it in months, but you're more likely measuring it in years.
Depending on
the
size.
Well, one of the big issues, I'll have to say this, one of the big issues is judicial resources, right? We do not have the judicial resources to say that I want to go to trial next week. Well, that's never going to happen. You can go to trial maybe next spring, maybe, if you're only going to be a day or two, but more likely
that's because of the
summer.
court systems are that full.
And
can you go after costs?
You can go after costs. On the point of the court system that full, rightfully, the criminal cases do get priority. You're dealing with someone's liberty often. Those are where the judicial resources are going to get put initially. So it does take a little bit of a backseat, but they do. There are judges there that are going to hear it eventually. And can you get costs? Yes, you can get costs. You certainly are going to ask for costs. But even the successful party getting costs, which is the system in Ontario, the person that wins usually gets their costs. It's never the full amount of the costs.
Yeah.
It's usually going to be a percentage of what the judge thinks is reasonable. So you're going to get it knocked down twice. The judge is going to say, you shouldn't have spent $70,000, you should have only spent $50,000 in costs. And then we're going to knock it down to 60 or 70% of whatever I think is reasonable. So you're going to take a hit. You have to make sure as someone who's going to be going through this process and at every step as well, when you're thinking about negotiation, about resolution, about mediation, coming to a negotiated agreement, you got to think, how much is this going to cost me? Because as you go deeper and deeper into the litigation, to the dispute resolution, you're just sinking more cash fighting it.
So definitely having a consultation with a lawyer prior to all this stuff, right? To figure out, like, if it's a $20,000 dispute, that's going to cost me 50.
Right.
Right.
And as you probably did or should have been doing with your contractor when you're going through the renovation process, you should be asking your lawyer, what's the cost of this next step? Right? And the lawyer should be able to ballpark. You can never be totally sure, just like in renovation. I don't know what happens when I open up whatever's behind that wall.
Yeah.
It's the same thing in the litigation. I don't know what happens when we get their affidavit documents and it's...
So we're now, not everybody's familiar with, where to find a construction lawyer.
Sure.
Now, we can all call Chad.
Sure.
He's at Blaney's.
Well, it's right here. What do you mean?
However, if somebody is trying to find a lawyer that specializes in the construction field, how does one look for someone like that, other than calling you?
Sure. Well, the Law Society has a list of people that they have certified as specialists in various areas of law, and one of them is construction. I have my certified specialist designation. So there are, I think it's 35 people throughout Ontario that have that designation. So that's one place to start. There have
their
been
website?
certain criteria on the Law Society of Ontario website. The other thing is, and this is something that I take seriously, like, lawyers should be sitting and doing their work, billing their clients, doing their file work, but they should also be out there doing education pieces. So they...
we thank you for coming.
Well, and glad to do it.
Oh.
I will send you the bill.
Send him the bill, okay?
Amazing.
But we should be out there writing, if not lengthy articles, at least updates about what's new in the area. So, for example, if you just Google adjudication in Ontario right now, there are dozens of articles out there, dozens of pieces written by very good lawyers.
But it's getting that information to the public, to our audience, for instance, that really, really helps to showcase the items for them to even research. Because to simply look up adjudication when you've never even heard the word before, no one's even going to know to look for it.
Yep.
I mean, that's why shows like ours that are helping to inform the public as to what are the surrounding items around the construction field, what within the residential sort of parameters, what do you have? Who do you know? What can you do? That's exactly what this show's about.
Sure.
So, I would say, thanks very much for coming out today. I really appreciate everything you've done. Thanks for coming out and explaining all these major big words and going through all of the complexities within this very actually complicated piece. I'm going to try and sum it up just as we go through what we've talked about, just because there's so many pieces of it. I'd like, maybe the ending of this to kind of try and sum everything together, and I think I can do it. I'm going to try. So
let's have a look.
We start out with, at the beginning of the contract, by putting together a proper job scope, having the job scope reviewed by your architect, and making sure that job scope functions within the contract. Having the contract reviewed by your lawyer, construction lawyer, who's going to look over those items to make sure that every item within that contract lends well to you and to your side of things, as well as keeping it balanced between the two,
between the two parties. Exactly. Yeah.
Thanks for the word. So from that point, the work would get completed. We'd reach to a 97%, which would be where if it's not listed in the contract based on the job scope, would it be a general feeling, I guess, to where that 97% would be at, which would be considered substantial performance?
Yeah, usually you go by dollar value of what's left to be done.
And then from the substantial performance aspect, there is a time period, whether you're before July of 2018, it would be 45 days. And if you're after July of 2018, it's 60 days?
Correct.
And so 60 days, you have that period of time that you need to pay the contractor and have the deficiencies cleaned up and be happy with the work. At that point, you can choose to pay the client, the contractor, or at that point you end up in holding that money, in which case the contractor in turn would put a lien on the property. Or
most likely. Yeah.
Most likely.
Yeah.
At that point then they would have to perfect that lien.
They do, yeah. You would get sued, yeah.
Yep,
they put the lien on, you'd get sued, yeah.
That was the suing part of it. And then it would go into resolution if you're after October of 2019?
You know what? There's going to be a resolution, mandatory mediation.
Okay.
There's going to be a mediation probably that takes place at some point.
Okay.
But it's the adjudication that happens if your contract is dated after of October 1.
So after October 1,
2019.
then you get into adjudication, which then is the items that we talked about, where you would have a 45-day decision made. At which point that 45 decision day period would then either lend to you paying your contractor, which you're now paying double because you've already put the money into court.
Probably, yeah.
Or you winning and not having to pay the contractor and you getting your money back out of court.
10 days to pay after, right?
10 days to pay.
I was listening.
If you lose, yeah, that's right.
you lose.
Now that said, and you know, I don't know if this is good or bad, but the adjudication, even if the homeowner wins on the adjudication, the contractor can still push forward with a lien action. So it doesn't totally end everything. That's still out there. The lien procedure is still out there for both parties to use.
And then the lien procedure would go into the court case that we just finished talking about that could cost anywhere between $60,000 per party.
Up, yeah.
And
60 up, yeah.
And
We'll
last
call it that,
potentially years.
Definitely, yeah.
Okay, so if we've learned something out of this today, it is to properly put together your job scope and your contract prior to you ending up in a position where you end up in a major resolution, or Chad will become your next best friend for the next 2 years, apparently, and would love to see you, I'm sure. However,
your bank account's best
And you
friend.
do not want to call me. That's. I just know that you don't want to have to call me, but
you're
sometimes
there
you
for
can't
a
help it,
reason.
yeah.
You can't.
Yeah.
You don't have to vilify yourself. You're there as a gladiator,
Yeah,
as my
that's
dad
right.
says.
The other thing is too, throughout the process, if you have an issue, you can go back and call the lawyer, right? If there's something that happens throughout, right?
To that point, too often we see these contracts. You know, we'll review them. We'll make sure the terms are there, and then everyone signs it. They have their initial kickoff meeting, and you take that contract and you open the drawer and you put it in the drawer, and then no one looks at it again. Like that's one of the biggest problems that we see is not following the contract afterwards, to make sure that people know that what their rights are under the contract and know that what has to happen at certain milestones, and they just ignore it. And it only comes up when the dispute's already arisen, even though there were warning signs, and you know, a little bit of reviewing the contract and sort of gauging what your options are could have avoided a dispute. We see it time and time again.
And that's what it's all about. It's about avoiding the dispute, and I think that sort of really sums up our show for today. Is contract law, lawyers, contract disputes, and how to avoid the dispute. With that, I'd like to say thanks very much, Chad.
Thank you.
I really appreciate you coming
Pleasure.
down. It's been an absolute enlightening experience for me. Brian.
Thanks for listening to Room to Improve podcast. Follow us, subscribe now, like us, follow us on all the podcast locations. I'm Brian Latanville with Healthy Home Makeovers.
Chris Potts with Northwind Construction.
Chad Koplatch.
Yes!
Chad, something.
Amazing. Cut.
Chad Koplatch at Blaney McMurtry.
Say it again.
Chad Koplatch at Blaney McMurtry.
We'll see you next time on Room to Improve podcast, sponsored by Improve Canada, Canada's largest home renovation super mall.